Hi, my name is Nick Weiss. I am the founder and managing attorney of MP Weiss Law with offices in South Euclid and Elyria, Ohio. We practice in the areas of real estate, family law, and estate planning and administration. Today, I want to talk about a question we get on estate planning, and that is, should I make my attorney the executor under the will? So this is not a legal requirement. You don't have to make an attorney the executor on your will. But there are circumstances where that's a good idea that we talk about in another one of our videos, how we choose an executor. And some of those things are someone who's trustworthy, someone who is reliable, has good financial knowledge, is going to be responsible, is going to be local. That's really all the best things and best practices for picking an executor. And sometimes that person just doesn't exist. There's not someone who meets all of those criteria. And in those kind of circumstances, naming your attorney can be a real benefit. Why? Your attorney, especially if they're the ones who did your estate plan, already has all of your financial information. They took it at intake, being a clear snapshot of your bank accounts, of your assets, of your cars, of your retirement, all the things that anyone who is going to be administering your estate needs in order to do that. We've already got it. We also are going to be familiar with the local probate, right? We've done this 100 times, 1,000 times, and can act in ways that maybe the spouse or the friend or the child that you otherwise nominate as an executor won't know what to do and won't be familiar, and that can lead to hiccups, that can lead to delays. And that brings us to the next part, efficiency. When a person is named an executor, often they will hire an attorney to assist them in administering the estate. That's a good best practice. There are functional procedural hurdles in administering an estate. One of those is that most filings have to be signed by both the administrator, executor, or fiduciary of the estate and the attorney. So whenever we're drafting someone, when we're drafting an inventory or accounting or even doing just general correspondence, the attorney is drafting all this stuff. It is sending to the executor. The executor is reviewing it. The executor is signing it and sending it back for the attorney, who is then signing it, who is then putting all the beneficiaries on notice of that signing, filing it with the court, and getting it set. Okay? That's about 4 extra steps that we can get rid of entirely if the person who is administering the estate is also the attorney. We say in another video that your average estate administration in Ohio takes up to a year. If you have the attorney be the person who's administering that, we can cut down on that timeline substantially. One of the questions that we get is it more expensive to have an attorney be both the fiduciary and the attorney, right, compared to just nominating an executor to be the fiduciary for the estate? And the answer is no. In Cuyahoga County especially, an administrator, executor, fiduciary's fees are set by statute as a percentage of the estate. That's true whether it's a lay executor, that's true whether it's an attorney, right? That amount is going to be the same regardless of how that goes. The other part of costs for any estate are attorney fees. Again, in Ohio, especially in Cuyahoga County, there's a local rule about the percentage there, right? That most estates are going to fall into. There's a percentage amount that the attorney is going to take as a fee for acting as the attorney. And so for most of the times, it's a wash. There are times, though, where an attorney in Cuyahoga County and surrounding counties will charge more than what the local rule is, what the percentage is. And we call those extraordinary fees. And oftentimes, we ask for extraordinary fees when it's been difficult to administer an estate. It's been hard to track down an administrator. It's been hard to get bank account information. It's been hard to talk to the beneficiaries. We've had delays. We've had additional expenses, those kind of things. And a lot of times, that's just hard communication with an administrator or an executor who's maybe not sure how to access that bank account, not sure how to access that retirement account. And so they need additional guidance, additional forms, additional procedures there that result in a higher attorney fee bill. If you have the attorney already acting as a fiduciary, they're going to get it right. they're not going to be confused about getting access to that bank account. They're not going to be confused about getting access to that retirement account or that life insurance or that stock portfolio. They will already know how to do it, right? And so you won't get those extraordinary fees. You won't get that cost to the estate above and beyond that percentage. So assigning the attorney can actually cost you less money on the estate than having someone you know and trust act as the executor. So should you always have the attorney be your executor? Not necessarily. There are plenty of people who are more than qualified and competent to act as executor to administer the estate. But there are some times, especially when you are struggling to find someone to meet those best practices criteria, that naming your attorney, the person put the will together, as the executor can save time, can save money, can save headache when it actually comes time to distribute your assets. So if you have more questions about this, about whether you should assign the attorney as executor of your estate, feel free to reach out. Happy to have a consultation with you and see if we can help.